Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is What I Wish I'd Learned in Law School, How to Run an Ethical Office. Speaking today will be Claude Ducloux. Claude is an attorney licensed in Texas, Colorado, and California who regularly speaks on law ethics, law office management, and trial-related topics. In 2011, he won the highest statewide award from the State Bar of Texas for lifetime contributions to CLE and has been invited to speak at more than 150 programs since 2009. Mr. Ducloux has a long legacy of bar service, including being president of the Austin Bar Association and serving as chair of almost every major bar-related entity, as well as the Texas Bar Foundation. The presentation today will be followed by a Q&A. Please enter your questions into the question box in the webinar panel on the right side of your screen. All questions will be addressed at the end of the presentation. We're recording this webinar and will be sending the video and a follow-up email in a few days. We'll also post the video on our blog, which is www.lawtechnologytoday.org. Thank you all for joining us. We'll now begin the webinar.
All right, thanks very much, Austin. This is me, Claude Ducloux. I've been a lawyer, well, actually, as of June, it'll be 40 years. In Texas, they have allowed board certification. I'm certified in civil trial, civil appellate law, and I do all that good bar activity. Let's talk about, this is really part of an hour presentation that I've chopped down to 30 minutes to fit it into this, so there's a lot of things. Now, I want to tell everybody out there listening, though, that afterwards, if you have a question, we'll have a question and answer period, but you can also email me your questions. If I mention a document that you might want to see or use, email me, just claude@lawpay.com, claude@lawpay. Sometimes I get over 100 emails, and I'm happy to, if you just hang on, I will answer every single one of them, because there's a lot of things that we can do that you know, you might be interested in getting the form for. But here's what we're going to talk about very, very briefly, the potential client, how you do that, documenting your representation with a client, and then the things that you need to do to run your office. And then I'm surprised that I still have to talk about using a trust account, but apparently there's a lot of people that didn't get the opportunity to have a professor teach them how to use a trust account, so this is being used improperly, and it's not that difficult, so we're just going to spend about 60 seconds on that. Here's the 5 most common problems in the United States of America across all 50 states. The complaint number 1 is, my lawyer won't communicate with me, and I will tell you the communication is the number 1 word in the entire practice of law. Communicate with everybody vibrantly, actively, and by doing that, you sort of control the narrative of what's happening in the case if you will be the one that communicates with your client rather than make them beg you. Then neglecting the case, that usually results in number 1 above. You don't want to communicate with the client because you've lost interest in that case. Handling the attorney-client relationship long after they sign on. You want that client to be confident in you, and you know the things you need to do and the things you need to keep them abreast of, and always be honest with that. And then poor billing habits. Unless you have some big, huge $1-million trust that's supporting you, or you're working for your family, you want to bill for your time. And the idea is that you want to bill promptly, you want to bill accurately, you want to do things that make people have confidence in what you're charging them and give them the way to pay you. Now, one of the reasons that I had agreed to become the education director for LawPay is because 10 years ago when I signed on, it just turbocharged my practice. Now, I'm an old guy. I have a 6 in front of my age, but I wouldn't have taken credit cards 10 or 15 years ago. And then when I signed on to LawPay and allowed my clients to use LawPay, it turbocharges your collections, and you let them keep their miles and their points, and it's very, very well worth it. And it's the way, because 65% of America pays with a credit card. And then the misuse of what we call retainer accounts, although that word is in flux, and I'll explain what I mean. So let's talk about it. The potential client. Your intake with that client is your chance to bond with that client if you're going to be representing them. Assess the client history. Listen respectfully, intensely. Give them your full intention. Don't take phone calls. Don't take emails unless it's a federal judge calling you to appoint you to the Supreme Court. But really, really give them the respect that shows that you're interested, because you know, if you don't and you cut them off early, or if you think you jump to a conclusion, they're not going to trust that you care about their case because you haven't listened all the way through. Get with our psychotherapy colleagues who tell you that healing begins when people think they're being listened to. So listen very intensely and really ask good questions. Ask good, and then ask that client to repeat key facts to you. Keep good notes of those because they will help you later when the client changes in his story. And it is too long to talk, but clients remember the things the way they want to remember them. And 6 months after something that they're very troubled about, they change, the narrative changes in their own mind, and so that's why you have to keep those good notes to remind them. Now, remember when you came in February 1st, you told me this was the fact. Isn't that correct? Oh, yeah, I guess that's right. So take good notes. And then you have to discuss what your client expects, because the goal of any client interview is reasonable expectations on your part, reasonable expectations on the client's part. They know what to expect of you. You know what to expect of them, and one of those is that you expect to be paid. Inform them. Give clients lots of information. I think the best thing you can do to protect yourself and to make the client happy is invite them to ask you questions. Invite them to email you questions afterwards. What's going on? I just sent a long email to a client not 30 minutes ago who said, okay, we finished the case, but the other party might appeal. What does that entail? And I said, here's kind of the timeline if that were to happen. Always respond, always give them the respect that you would expect for them to give you. Cost, alternatives. Tell the client you might be able to resolve something for them with just a couple of letters if they're willing to take 80 to 85% of what they're expecting to get. Would that be enough? Give the client the alternative. If it's a consumer case, you say, look, I can probably get your money back, but I won't get damages and I won't get attorney's fees. But if I get your money back, will that be good enough for you? Because a lawsuit to get attorney's fees, etc., is going to take a lot longer. So give them those alternatives. All right. And here, what I've learned in my almost 40 years is 2 interview questions you absolutely must ask before you take on the case. And you can ask number 1 here as diplomatic as you. What do you think I can do for you? Now, the reason you ask that question is to see if they already have a preconceived notion of what they think their case is worth or what you think they could do. Well, I need to get $1 million, or I need to for you to finish this within 30 days. If they have an unreasonable expectation, you have to talk them down off that expectation, or you have to pass on the case. If they think they can finish a case that you know is going to take 6 to 9 months, depending on the cooperation you get, in 30 days, you have to say, I will not be able to do that. Or if they think they can get $1 million on a case that's worth $20,000, then you say, well, you go hire the lawyer who told you that your case was worth $1 million, because I can't assess it that way. I mean, be nice, but the whole point is make sure you get what the client expects you to do. And the other thing is, because clients, and especially prospective clients, you may not be their first interview. They learn what to leave out of the interview. So you always say, okay, great, I like you, I think I can do this, this is in my wheelhouse, it's the type of but help me out here. In this first phone call I make to the other party, the other side, what are they going to tell me about you? It is the most important question you can ask, because it opens a Pandora's box. They'll say, oh, well, they'll say that I've had 2 DWIs, I've been, divorced 4 times, I've been through bankruptcy, and of course that has nothing to do with the case, but it's what you haven't been told. So make sure you give them the opportunity to, what I say, prophylactically protect you from all this bad information, which is going to be 100% true. The other thing I always say, when someone says, well, I need to sue this person for the principal, you can be absolutely sure that you can never make that person happy. People who come in for the principal, I don't need the money, but I'm suing for the principal, have an unreasonable expectation coming in, and you either have to get them into a reasonable spot or you need to pass on that case. It is an absolute law. No one has ever told me I've ever been wrong when I've given that advice. Okay, the goal, as I said, reasonable expectation. A good interview results in reasonable expectations for you and your client. And then you have to ask yourself, do I really know how to do this? I mean, I am not going to take on an estate planning case that involves making complex marital trusts and pour over trusts and things. I can't do that. Don't pretend that I can steal somebody's forms and do complex estate planning. It's a way to get yourself in trouble. It doesn't mean you can't learn a new area of the law. I give the story where I did my first habeas corpus case, even though I don't do criminal law, maybe 7 years ago. But I was a smart enough lawyer to know to look at the correct forms and say, yeah, this fact fits, and learning how to do that. So it doesn't mean you learn how to do 1 or 2 little items and you stick to that your whole career. be bold enough to learn a new area, but learn it correctly. And then ask yourself too, really, do you have the desire to help this person? Are you doing it just for the money? It's going to affect the way you treat that client. If you think, well, I can probably get this done in a couple hours because I don't really like this person, but it's money in the bank, so I'll go ahead and do it. Don't do it if you feel that way about it. And of course, then do you have the technology? Don't do a case where you know there's going to be 3 other parties whose legal assistants are going to be blitzing you with discovery all day long, and you won't have a chance to go to the bathroom during the day because you're going to be kept. So I can't do that. I don't have in my office, with a couple of attorneys and secretaries, we can't keep up in a big mass tort case. We would never take that kind of stuff. So don't take stuff you can't handle. Okay, ask the client, what's your objective? Is it to win? Is it to delay the inevitable? If they're being sued and you're representing the defendant, they say, look, I'll have money in 6 months when my tax refund comes in, or I'm getting an inheritance. Just make it last this long. Or again, remember, if they say I'm suing for the principal, you're going to be in trouble. The speeches I always give, conflicts up front. One of the first things you do in a good interview is ask, wait a minute, if this involves multiple people or parties, who else is in here? Now, you might think if you're a young attorney, I don't have any conflicts, I don't have any work, I'm going to have a conflict. But I tell you, even though Austin is now over 1 million people, I have conflicts of interest all the time after 39.5 years practicing law. Oh yeah, shoot, I just had a case where the expert on the other side was a wonderful engineer who I handled his divorce, but he'd be testifying against my clients. Well, I didn't have any problem with him or his testimony, but I got conflict of interest waivers from my client and from him and from the other client saying, if you're going to use him, I'm going to disclose that I've done his divorce. He doesn't have an objection to me, and I don't have an objection to him because I think he's an honest person. But your client might say, well, I don't want you to, if you guys are friends, I don't want you to be friends with somebody else. So always get those waivers up front. And then if they come in for a transaction, well, we want to start an LLC, always ask, who do I represent? Bob here or Jim here or Mary has been my client. She's coming in with her friends, Debbie and Bob, and the 3 of them. I said, wait a minute, she's my client. In this LLC, what am I representing? Am I representing Mary? Am I representing the LLC? Let's make sure I know what entities are involved and what might become involved in the future. If you find out, yes, we're going to file this LLC because we're going to challenge the zoning on a shopping center, you go, oops, I represent the real estate company. I can't do this. Is going to assist you in attacking some venture of my other client. Then documenting the representation. You never underestimate fees. Clients only remember what they want to remember, and that's only going to be the lowest fee you quote. So if they say, I've come in and we've agreed on everything, how much will it cost just to paper this? And of course you fall for that and say, oh yeah, you've agreed to everything. Okay, I'll do it for $1,000, $1,200. And then you find it hasn't been agreed to, and it's a much longer process. And they say, you said you'd do the whole thing for $1,200, and it doesn't do you any good to say, and you said everything was agreed to. They will expect you to be the expert, so be very careful. And then always, unless you're working for free or doing pro bono, and I do a lot of pro bono, I'm doing a pro bono probate tomorrow morning, but always discuss fees up front. Never underestimate. Always say, make sure they understand that you need to be paid. You absolutely positively need to be paid, or you're going to withdraw from the case. Is there a payment plan? If so, if not, don't start the case. And if somebody says, well, I'm going to send you the retainer, or now they call it the advanced payment of fees because retainer is reverting to its old definition, meaning just a flat fee paid for the right to use your law firm. So be careful of how you use retainer. It's got a definition that's in flux. You can use advanced payment of fees. They say, don't worry, the fee's coming next week. Don't get started. Just say, I can wait until the fee comes in. And what should be in the good fee agreement? The scope of the work, the basis of the fee, who's going to be working on it. Now, I know I'm going through this quickly, but I think this is going to be made available to you afterwards, and you can use it. This is a short form of agreement of an hour-long talk that I usually give on this. The basis of the fee, who will be working on it? It's you. You have a legal assistant. Who's that legal assistant's name? With an associate? How will you update communications? By email. I send lots of emails to clients on the weekend when I have calm time to sit here for an hour and a half, and I say, dear Raj or dear Bob or dear Mary, let me let you know what's going on in your case. I know that interrogatories were due last week, but they asked for an extension, and I gave it to them because I knew the court was going to give them to them, so that's why you haven't heard from me. Feel free, of course, always. When I was a grievance prosecutor, and I prosecuted hundreds of lawyers both as a bar counsel and then as a volunteer, we always said if there were 3 letters, this is before emails or faxes, if there were 3 letters from the client, from the lawyer to the client, there was never a grievance, because the lawyer was trying to keep the client informed. That's what I do. I send out hundreds of little emails to protect myself, to say, hey, here's what's going on. Call me if you have any questions. I'm happy to do it. Just do that. Communicate, communicate, communicate. And if the client tries to change the narrative by saying, well, remember in our February 1st meeting you said that this would take 30 days, make sure you always respond respectfully, diplomatically. No, that's wrong. I don't know where you got that from, but as my notes reflect, this was going to take a minimum of 90 if I got cooperation. So I don't want you to have any misconceptions about always control the narrative by responding to incorrect email to you from your own client. Now, the other thing, most states are now, and Texas and several other states, absolutely mandatorily, you have to have a privacy policy. That doesn't have to be 5 pages long like you get from credit cards. That can be a 4-sentence privacy policy. If you want to add one into your thing, please, to your agreement, email me, Claude at LawPay. I'll send you a sample privacy policy agreement. I also put a file destruction clause where the client, when they sign on, agrees that after 4 years, unless I'm required by law, like it's something involving a minor who hasn't turned 18 or 20 yet, that I have the ability to safely shred, destroy, or delete the file after 4 years. That saves me a ton of time, because when I moved offices last year, I spent 40 hours going through 1,500 files. I don't want to ever do that again. So always put that kind of stuff, the amount of prepaid fees, or what we used to call retainer, and disclosure that it won't earn interest. Now remember, if you do have a conflict, you have the duty to disclose it, secure permission, withdraw where appropriate. Complete disclosure under the model rules, the Texas rules, the California rules, are all these things. You have to tell the client, hey, here's the conflict, here's what the nature of it is, here's the implications of it, here's the adverse consequences. For example, if the conflict is, well, I'm representing both of you, but now we've just found out there's only one single $100,000 policy, you're going to have to share that. The conflict is, you may get in an argument about, well, wait a minute, my injuries were worse than yours, I should get more of that. And here is how I propose to handle that. You can all get your own attorneys, but we can have a resolution process like this, and then the advantages of common representation. Running your office. Too many lawyers think, I am going to be so busy that I will give some legal assistant the right to sign checks. Don't do that. Don't do that. I don't even want to give you an exception. You have enough time to sign your checks. You or another lawyer in your office should be signing the checks. And if not, the dirty little secret of the profession is embezzlement is rampant, especially among big firms. Just in the last 4 years, I can tell you 4 firms in my city, Austin, Texas, who have had embezzlement. And these are fine, wonderful people, but they say, we're too important, we're too busy, we can't sign checks. We're going to let this new a legal assistant or sign checks, and they get in trouble. Embezzlement's a problem. So let's move on. Payment systems. This is the lifeblood. The lifeblood. How do you bill? How often? I'm one of those old timers who uses time slips, but absolutely, today is the first day of the month. My bills for January have already gone out today. They're in today's mail. Those clients who want them, and the ones that want them who want them by mail, and those which are now increasing, probably 50-50 of my clients do not want mail. They want their bill electronically. So I send that bill electronically, and I send with a link to LawPay. It's a dear Bill, here, dear Joe, here's your bill for the month of January. Of course, call me if you have any questions. If you want to pay me now, hit the Pay Claude Now hyperlink in this email, and you can just pay me safely and securely at LawPay, and it works like a charm. The other thing that I will tell you when I'm doing my bills is this. Last night when I was getting ready to finalize my bills for January, I saw, hey, 4 of my clients didn't pay me last month. I just swing my chair around and type each one of them an email, all 4 of them, say, hey, dear Jim, I noticed you didn't pay your bill from last month. It was, $285 for doing that. If you didn't get the bill, let me know, but otherwise, why don't you hit this link and pay me now? I will promise you 3 out of 4 last night paid their bill. There was only one of the 4 that didn't immediately get embarrassed and send me an email. Oh gosh, yeah, I did get the bill. I just overlooked it. I was busy this month. Here it is. And then you get an email saying, you know, Jesse has just paid you but through LawPay, and they get a bill saying you've just paid Claude through LawPay. Here's the other thing I want to show you on this graph. And that is people pay most often when you bill them right after you've performed the service. This is a famous you know, chart that Jay Foonberg in California did. He's an old lawyer now and wonderful a writer on office management. He says, you know, if you wait 30 days to send out your bill, the client thinks, wow, that lawyer sure is proud of his bill. If you wait 60 days, say, wow, there's no way I'm paying that much. And after 90 days, they'll say, I didn't even need a lawyer for this. So, and I can tell you, people hate getting bills from the big firms in October for work they did in July or August, because you can't remember what was done in July and August. But when my bill hits them today, January or February 1st, for stuff they did in January, they remember. And I know by the end of the day, I'm going to get at least 5 or 6 more payments through LawPay. All right, strive for 90% collection rate, and that is, you know, get your bills out. What about recording time? Look at tip 1 on this slide. When I can't remember what I did because I had a hugely busy day, I just go to my email. I look at the sent. What did I send? Oh yeah, I did the deed in the Hancock case. Oh yeah, I did a letter in Mr. Crockett's case. Yes. Oh, I did this. I did. You know, it is a huge treasure trove of information of what you did and what you sent. And then when you're writing your bills, don't use shorthand like check file point 3. No. Discuss with Bob upcoming, you know, pretrial hearing and possibilities for, you know, progress, you know, blah, blah, blah. And of course, you never write secrets in bills. You never do confidential information, because if you're in a situation with an opposing party who gets to see your bills, the trend in the law is that you can't redact anymore. So just say sent settlement offer, not how much the settlement offer was in that bill. And then so that's the tip number 3, don't use confidences. The other thing that I've got to say, remember to psychologically speaking, it's got to be a nice looking bill. You need to draft bills that are easy to understand and demonstrate how hard you're working. Hey, that extra ink in the printer costs you nothing to expand. Make that entry, you know, 2 lines rather than 4 words. 3 lines. It says, wow, yeah, he did all that work for 0.3 hours. That's a lot of work to do for 0.3 hours. And then throw in activities. The client called to and asked about this. I responded with an email, no charge. You know, those things. And here's some really bad billing habits. Making the stapler a profit center, charging for binding and office supplies. People don't expect just because they hired you that you have to run down to Office Depot and buy paper. Don't charge them for office supplies. Don't charge a surcharge if you're using a credit card. That puts an additional steeplechase in front of them wanting to pay you. Oh, man, you charging me extra $35 because I'm using a credit card? Don't do that. That's stupid. Don't charge for legal or, you know, excessively. Don't say legal search 8.2 hours unless you're a appellate lawyer who can do it. Your file review, file update, and then don't charge too much. Should you ever sue a client? I'll tell you, it's probably not. You don't sue it unless it's an existential threat to you or the firm. In other words, you can't stay in business if you don't collect this fee. But if you do decide to sue, remember that their counterclaims are usually compulsory. And I always say going to an ADR committee of a local bar. Austin has a wonderful fee dispute committee, and it really works hard to be fair to both the client and the lawyer. I've had very good experiences anecdotally. I've never had to go, but I've had to go as a witness for a client for their, you know, being sued by their old lawyer, and the committee does a good job in adjusting what they think the fee should be. And then make paying me easy. See, when I send out my hyperlink and they hit on that, you see that invoice, that's what mine, in fact, I think I have in this next slide what mine looks like. There you go, Law Offices Claude Ducloux. There's my website, claudeducloux.com. It has a make a payment tab. I think, actually, I just changed the front of it, but it has a make a payment. And then when you hit that, and this is the same link I send in emails, it allows them to write in, just like I'm a doctor's office, the amount they're paying. You know, I don't put invoice number, but you know, the name of the client, cardholder information, and then they click pay. And it's great. Then they get an email, and I get an email. Now let's do this really quickly. IOLTA trust account. Most states, some don't call it. They just call it a trust account. We call it the IOLTA, interest on lawyer trust account. The only thing that belongs in there are client funds which haven't been earned, or client funds being held in escrow for an event or a contract or a cost. So here's the closing money to purchase that business. What doesn't belong in there? Your money. When you earn it at the end of the month, like when my bills went out, there were about 4 or 5 bills that had how much to be deducted from my trust account. My legal assistant compiles that number into a final number, and she writes one check from the trust account to me that I will put into my operating account. And in there, it designates this is, $612 from the Crockett case. This is, blah, blah, blah. So there's a clear, traceable thing. Now, you can do this electronically too. I'm an old-fashioned person that I'm getting more into transferring money electronically, but accountants love to have a paper check that here it is. Here is the check that transferred it to you. And non-refundable retainers, absent agreement, non-refundable are similar to a flat fee, and they don't go in a trust account. Okay, here's 6 concepts as we're winding down here. I think I only have about 3 or 4 minutes. There was a big survey about the things that that attorneys believe that clients want, and then they asked a big survey of clients, what is the most important to you? So here are the 6 concepts, right? Competence. Yes, I want a good, competent attorney. Accessibility. I can get a hold of my lawyer. I always say in my fee agreements that I have a client's rights section that says you have a right to be contacted by me or a member of my staff within 24 hours, 1 business day of any contact to my office. Doesn't mean I may not be able to, but someone in my office will let you know why we haven't been able to contact you. Collaboration, that means you understand the client's goals and you are dedicated to achieving those goals. Accountability, you don't blame things on the secretary or the judge, or the worst thing lawyers can do is say, well, we went for a hearing, but that darn judge, he or she just didn't understand the case. No, when I'm in an iffy situation, I will tell the client, look, we probably should win this case, but we don't know in our central docket which judge we get, so it's very possible. It's worth it for us to file this motion, but I can't guarantee we'll win. We should, or else I wouldn't find it, but if the judge rules against us, that's all part of being a lawyer. So you don't blame somebody else. Communicate. You respond to those communications and you tell them in clear terms what's going on. Then respect and courtesy. I want a lawyer who's going to respect me and treat me like so let's see. Here is what the clients really want. Number 1, they want collaboration. Again, team. You're a team with the client. That you have had that great first interview and you've shown the client that you understand the case and you're going to try to achieve their lawful goals. Number 2, you are accessible. When they call your office, they know they might not be able to get you, but you don't say every other time, oh, he's in court. Nobody's in court as much as a lawyer who doesn't want to return a phone call. So that's really, really important. That you're a good communicator. You explain the law. You explain what's going on. You explain what the other side did. You take the time, or just say, oh, I don't have time for this, to really make the client understand, because so many of my clients have been friends for life. You take accountability for what happens in the case. These were decisions that you made together, yep. And you don't say, again, it was somebody else's fault, or it was the judge's fault, or it was my secretary's fault that she didn't get this out on time. Nope, I'm the captain of the ship. I'm going to be accountable to you. That you do give them respect and courtesy in the survey. That's what they say. And then look what came in last, strangely, is competence. Now, I have wondered over and over in these years that I've been using this, but I think it's because if somebody's called you, they've already figured out that you are competent in your area of the law. So we are almost into our 30 minutes here. I'm sorry that I have gone so fast, but if you have some questions that you want to ask or pose to me in about 60 seconds here, I'm just going to get off the line and let you pose those questions. And again, if you want to write me your questions because they're too long, do that. So here's our final thoughts. Make sure you interview in a way. Have a written agreement with the client. Communicate often. Take charge of the narrative. Have excellent billing habits. Send out your bills. Make it easy to get paid. And don't sue if you get burned. It's all part of doing business, and use ADR with your clients when available.